I will deal with the issues that appear on paragraphs H and I and L of the request for referral, which issues, my lord, deal with the aspect of bail.
You want to adopt a rolled-up approach? Do you limit once, or you want to deal with
Yeah, indeed, my lord, I intended to deal with them in a rolled-up approach because they relate to the appeal that the accused persons had noted against the determination of the magistrate's court.
I'll suggest that you deal with the issue separately, so that we don't get mixed up.
Indeed, as the court places, my lord. So I will start with the issue number H, whether the refusal of this honorable court to entertain the appeal of the accused persons under HCHA CC 126/24 on the basis that the indictment rendered their appeal moot, whether or not that amounts to a violation of the constitutional rights of the rights of an accused person as enshrined in section 50 and 70 subsection 3 of the Constitution, and whether or not they violate the accused person's right to challenge the correctness of the magistrate's court decision, and whether or not that determination violates the right of the accused persons to the equal protection and benefit of the law as enshrined in section 56 subsection 1 of the Constitution. Lord, the facts upon which this aspect is premised on are common cause. The facts are that the accused persons were charged in the magistrate's court and they applied for bail. After applying for bail in the magistrate's court, the bail application was denied. After the refusal of the magistrate's court to grant them bail, and the refusal of the magistrate's court to release them on the basis that they were coming from home, the accused then lodged an appeal to this honorable court. When they lodged an appeal, the appeal was set down to be determined on the 6th of, my memory serves me well, on the 6th of August. And after the initial appearance, the matter was postponed to the 8th of August. But before the matter was reheard, the accused persons were then both indicted to the High Court in terms of Section 66. And on the 8th, the accused persons appeared to argue their appeal. In arguing their appeal, the state raised a point of law in which the state indicated that the effect of the indictment is that it rendered moot the appeal that was pending. And this honorable court agreed with the state's point of law. It then denied to hear the appeal on the basis that the appeal, according to the court, was now moot. The point that we raise as a constitutional issue in respect of that is that the court, in its interpretation of the provisions of the Criminal Procedure and Evidence Act, found that once an indictment, once the accused persons are indicted, it therefore meant that any appeal that is pending is moot. And it is our respectful submission that in doing so, the court was violating the rights of the accused persons to seek to correct a decision of an inferior court, and therefore, in our respectful view, it violates the right to the protection of the law. The accused person relying on the aspect that it is our submission that any accused person has a right to challenge the correctness of any inferior decision on appeal. The decision that they sought to challenge was, firstly, whether or not the court, the inferior court, was correct in determining that the accused persons were not coming from home, they were coming from the custody of the ZAC officials. That issue was therefore not determined whether or not the court was correct. Secondly, the issue of whether or not the accused persons ought to have been admitted to bail was therefore not also determined. So the accused person submits that the right to appeal is absolute and it cannot be interfered with. And it cannot be expressly taken away, and it cannot be taken away even by statute. So in effect, when the court refused to entertain the appeal itself, it was therefore determining that the accused person's right had been suspended. I will refer this honorable court to its decision in the matter in HC ACC 126 of 24.
ACC
126 of 24. Just be with me, Lord. In particular, on page 6, the second from bottom paragraph, where this Honorable Court held that there is no provision for the liberation of the accused person before he or she appears before the trial court. There is therefore no a deliberate statutory derogation to the right to bail before trial. So in effect, this court was finding that upon indictment, but before trial, the accused person's right to liberty or the accused person's right to make a bail application is therefore suspended until a trial is commences.
So are you mixing the cases? Are you dealing with the bail judgment in the bail application or judgment in the appeal?
I'm dealing with judgment in the appeal, my lord.
So why would you then refer to bail application?
My lord, I'm referring to what the Honorable Court stated in that.
No. You are saying that the effect of that was to take away the accused's right to submit a bail. And I'm saying we are dealing with a decision in an appeal, not a bail application. I'm sure you understand the distinction.
I do. Maybe let me retake that, my lord. The point that I'm making is that in refusing to entertain the appeal itself, the court was refusing to entertain a bail application. I say so because in terms of the law, even though an appeal against refusal to grant bail is an appeal, but it has been defined in numerous cases that it is sui generis. And when the court deals with an appeal against refusal to grant bail, it is in fact dealing with the bail application. It sits as a court that is dealing with the bail application. So in that regard, my submission with respect is that when the court refused to entertain the appeal itself, it was in effect determining that the accused person's right to be admitted to bail is suspended once an indictment has been issued against the accused persons. In arriving at that, this court had went through the provisions of Section 66, Section 2 of the Criminal Procedure and Evidence Act, and the provisions of Section 137 of the Criminal Procedure and Evidence Act. And it then interpreted the sum up of those provisions to mean that an appeal will then be of no practical effect once that is done. My lord, the submission is that the point being made by the accused person is not frivolous or vexatious. It is a serious issue. It is an issue that deals with the totality of provisions of the law as far as they relate to indicted people. It is a novel issue as admitted in those proceedings. And it is an issue that ought to be referred to the highest court in the land so that we hear what the Constitutional Court has to say about the totality of those provisions and the interpretation, whether or not there is a time in respect of which an accused person's right to bail or to apply for bail or to appeal is taken away. So that those will be my submissions with respect to that point, my lord. The submission that I wish also to make now in respect of paragraph I, which deals
Sorry,
with
before you leave that issue raised in paragraph H. Let's just interrogate together the issue that you want this court to refer. The first line, can you read it?
Whether the refusal of this honorable court to entertain their appeal under HCH ACC 126 of 24 on the basis that
you can stop there. What was the outcome of that matter?
the outcome of that matter, my lord, was the matter was removed from the
Is that correct?
If you could just bear with me, my lord, let me check. Or the objection of the state to the hearing of the appeal based on mootness is upheld and the appeal is dismissed. So the appeal was dismissed.
So did the court refuse to deal with the appeal or it determined it?
My lord, it then relates to the issue of interpretation of the effect of that. My respectful submission, my lord, was that a point of law was raised, which was upheld, where that point of law was that the hearing, the appeal was now moot. So the court then said, I'm not going to then deal with the appeal because it's moot. So
the court dealt with the appeal because it dismissed it.
My lord, the respectful point that I will make is that when a court dismisses or uses the word dismissal of an appeal based on a technicality or a point of law which has been raised as a preliminary point, it effectively has not determined the appeal on the merits, but he has dismissed the appeal on the point of law. So, if the effect
why should you want to put things put it in a manner which is different from what the court pronounced? Because the court dealt with it and gave judgment. In an appeal is either allowed or dismissed. So in this particular case, the court dismissed it. And the fact that you may have your own interpretation of it, or you may have a different view as to how the court should have disposed of it, does not really matter. But it is not correct. I will not be able to refer it in that manner, assuming that I accede to the request. It should actually be different whether the court's dismissal of the, because that is in fact what happened. The court did not refuse to deal with it. It dealt with it and dismissed the appeal.
Indeed, my lord, I do hear what you are saying.
So I'm actually taking issue with the manner in which the constitutional issue is couched. I mean, assuming we agree that the constitutional issue arises, but the way the draft constitutional issue does not convey.
I do hear you, my lord. Maybe I will then move that instead of saying refusal, we put whether the dismissal of the appeal.
You're already changing.
I'm proposing, my lord, I'm moving.
Okay, I see that you're already writing something. Because when you move for an amendment, you need to hear the state whether or not the amendment is
Indeed, my lord, I was only writing it for my notes so that I don't forget to see if it would make sense. So, my lord, I will move that that aspect on paragraph H reads that whether the dismissal of the appeal under HCHACC 126 of 24 by this honorable court on the basis that their indictment rendered
whether
whether the dismissal of the accused person's appeal under HCH ACC 126 of 24 by this Honorable Court on the basis that their indictment rendered the appeal moot amounts to a violation of the following constitutional rights. It will, in my respectful submission, therefore then captures correctly what the court stated in its disposition.
Thank you. State.
The state is not opposed to the proposed amendment.
I have another question. In other words, you ask, who is this court? Why are you referring to this court?
My Lord, I'm referring to this court as the High Court of Zimbabwe. If I may then move to the next one.
No. So you want me to express an opinion on the correctness of the decision of this court?
My Lord, I do not wish yourself to express your opinion on the correctness of the decision of the court, but I want this Honourable Court to refer to the Constitutional Court that issue of whether or not the decision of the court in effect was an infringement of the rights of the people.
No, it's not as if I'm a dispensation. I must apply my mind and be satisfied that the request is merited. So inevitably, then you are asking me to, pronounce myself on the, correctness or otherwise of the judgment of this court. Inevitably, whatever I'm going to say is really a comment on the judgment which I own as a member of the High Court.
My Lord, I must state that the judgment is indeed correct in terms of the law. We are not saying the judgment is not correct. But what we are saying is that the provisions and the interpretation of those provisions that was done by this Honourable Court, the legal system itself, therefore, takes away the right of appeal. And it is those provisions that the Constitutional Court must have a say on, whether or not the effect of Section 66, subsection 2, and Section 137 of the Criminal Procedure and Evidence Act, whether or not all those, the summation of all those provisions, whether or not they violate the Constitution itself, as far as it relates to the right of the accused persons to bear. That is the determination that I'm moving this on.
Okay, you are impugning the law.
Yes.
So, the issue arises at which proceedings? with the need to contest that law arises at which proceedings?
In my respectful submission, my lord, in these proceedings.
Not in the bail appeal itself, where the court was applying that law.
In part, they start to arise from the appeal itself. But in my respectful view, my lord, once the accused persons were indicted in terms of Section 66, as this honorable court held under the case that is under reference, this honorable court on page 4, the indictment is served on the appellant by operation of Section 137 of the Criminal Procedure and Evidence Act, deemed to be pending in the High Court, pending before this trial court. It is now an issue of when is the
Yes, I understand that, Mr. Tuta. You were before this court in that appeal.
Indeed.
And I'm saying the court was then applying that, because that was the basis for the objection by the state. They invoked, were you supposed to wait until we are here, we have congregated for this criminal trial, or you were supposed to raise it at that particular point in time when it was going to impact on your right, on the accused person's right to appeal, as you said?
With the point that I wanted to motivate next, relating to the bail application, it was an issue that this court was then seized with, whether or not any judge of this honorable court can entertain anything that relates to the accused persons who are indicted, or whether the trial judge can then entertain.
Let's stick to the issue. The issue is the law was being applied in that appeal, and you have been informed by the state in their notice of appeal that they were going to object to the hearing, to tell the hearing of that appeal on the grounds that it is good. And you know, you were well advised of the legal provision that you could find. And the matter was determined without you raising that constitutional issue. My question to you, in terms of timing, when should you have raised it? Do you have to wait until some other proceedings are commenced, or you have to raise it at that particular point in time, in that particular appeal itself?
My lord, the interpretation and the submission that I made was that based on the exchange that we then had with the court in respect of what does the law refer to as a judge, and the position was that the judge can only be the judge who deals with the trial. It is based on that interpretation that we felt the matter had to be raised.
We must very careful not to mix the two cases, because I'm aware that there is your challenge based on the bail application that followed.
Yes.
All the state said, remember that judgment very well, is that you are not precluded from making your application to bail. But there was no point in dealing with an appeal when the matter is already before the High Court. The High Court can consider the issue of the bail application. So the state was not really saying, don't be happy. It was simply saying, follow the procedure of the bail. And what I'm saying is, lest I lose focus. The issue is, don't you think that, in fact, it's not the proper thing that you should have raised that point at those proceedings, rather than to wait for them to terminate and then you raise it in some subsequent forum?
I do hear you, my lord. The issue is that the constitutional issues arose after the dismissal of the appeal itself. This is
No,
where
no, you are saying you are impugning the law that was applied by the court correctly.
yes.
Yes. So you cannot say that it was after. The fact of the matter is that you have no problems with the decision itself, because based on the law, which had not been impugned, the court came out with the judgment which you agree with.
Yes, my lord.
So my question is, if you thought that this law would result in an injustice or in a judgment which is correct, but which perhaps is the outcome of a law which infringes upon your franchise, you should have impugned that.
My lord, the hope was that the court was going to interpret the law in a manner that is in line with our submission in terms of the constitutional provisions.
So you were deliberately abstained from impugning the law because you were hoping for a favorable outcome. Is that what you're saying?
No, that's not what I'm saying, my lord. You will note that in our arguments during the appeal, my lord, we motivated this honorable court to interpret the provisions in a way that gives or is in favor of the accused person's right to liberty. And the court did not make a decision up until it dismissed. In other words, the court may have been swayed with our argument that the court ought to have found that those provisions were unconstitutional and that the court was not barred from hearing the appeal on the merits. The court could have been swayed by that.
You see, I want to understand. You seem to be contradicting. You accept and agree with the interpretation of the law. That's what you say. The judgment is correct, which means that you agree with the conclusion that the court arrived. But unfortunately, it was based on a law which you ought to have challenged. But the fact that you have your own interpretation means that you now concede that your interpretation is incorrect, because you now agree with the interpretation which the court gave. So my question simply is, this was a law being applied, and which had been invoked by the state. And if you are of the considered view, or you were of the considered view that that law was inconsistent with the constitutional provision, was it not really the correct thing to do to raise the constitutional provision or even request referendum during those proceedings? Because this is an issue arising in those proceedings.
Indeed, my lord, I think the issue arose during extended, in the record will reflect.
I know. That was, I don't know what issue it is. I'm saying the law had invoked this particular, the state had invoked this particular provision. And you thought it was inconsistent with a certain constitutional provision.
Yes.
My question is, maybe I'll ask you for the last time, whether the correct thing would not have been to request a referral in those proceedings.
My lord, I will submit with respect that where a point has been raised regarding whether or not a matter is moot, the issue of whether or not to entertain the appeal becomes a discretion of the court. It is a discretionary power. So where one then motivates to the honorable court that it uses its discretion to entertain the appeal because of the Constitution, one will be correct to then await and hope that the court will adopt that approach. So one necessarily has to await for the court to then make a determination of discretion, or of the discretion that the court will take.
So you put your eggs in that basket. So I'm saying you consciously and willfully abstained from impugning the law. There's nothing wrong in hoping that you succeed. All I'm trying to ascertain from you is that was it a willful decision that you made? That there may not be no need for me to impugn the law now, because I hope that the court will interpret this law in my favor.
Yes, my lord, I believe the accused persons chose to await the determination of the arguments that had been raised.
Now, section 175, subsection 4, what does it say?
It says where constitutional issue arises during proceedings. Yes.
So, is constitutional, does that law arise in these proceedings, or it arose in those kind of proceedings?
With respect, my lord, we submit that it arises in these proceedings, because these proceedings start from the point of indictment up until now. My respectful view, my lord, is in defining what proceedings mean, this honorable court has to determine at what point do we say these proceedings have started. In my respectful view, the proceedings of this matter start upon indictment of the accused persons. This is when the accused persons are now officially before this honorable court, also which is in line with this honorable court's decision in the matter that I referred to.
So the appeal was not proceeded. You mean that the appeal was not commenced? Well, I'm just saying that an appeal is commenced by notice.
In appeal, yes, it commences by
anyway,
notice.
Why wasn't the decision appealed?
My lord, in bail matters, an accused person has a right of appeal once. So if an accused person raises an appeal and the appeal is dismissed as the court is determining, the accused person's further right of appeal is taken away by law. He cannot appeal to the Supreme Court from the High Court. So the issue stops with the High Court. And that scenario in its own, my lord, in my respectful view, must also motivate this honorable court to find in favor of a referral of such issues, because the accused persons did not have a right of further appeal to have that decision of this honorable court tested whether or not it was correct.
Very well, you can proceed.
Thank you, my lord. The next issue that the accused persons raises is now my lord, whether the refusal of this honorable court to entertain their bail application under HCHACC 18324 of 24 on the basis that their indictment precluded them to make a bail application until the trial date, or unless if they anticipated the trial date, whether or not that amounts to a violation of their rights as an accused person, as accused persons as enshrined in sections 50 and section 70, subsection 3 of the Constitution of Zimbabwe, and the right to equal protection in benefit of the law as enshrined in section 56, subsection 1 of the Constitution of Zimbabwe. My lord, this point I would beg leave to deal with it together with paragraph L for purposes of because they are more or less the same submissions. Paragraph L, my lord, reads whether sections 66 subsection 1 and section 2, subsection 2 is read together with section 137 and 169 of the Criminal Procedure and Evidence Act in respect of an accused person indicted, such as the accused persons in custody.
That's what's H.
That's a L. As interpreted by this Honorable Court in HH 359 of 24, in brackets HCHACC 126 of 24, and HH 409 of 24, in brackets HCACC 18324 of 24, amount to a violation of their rights as accused persons as enshrined in sections 50 and section 70 subsection 3 of the Constitution, and the right to equal protection and benefit of the law as enshrined in section 56 subsection 1 of the Constitution of Zimbabwe. I beg leave to deal with those aspects at once. They relate to the same principles in respect of
one reveals judgment, the other reveals a law. So they can't be so you may proceed to deal with time.
The facts of the matter which are common cause in respect of this ground, my lord, is that the accused persons then lodged an application for bail to this honorable court. And this honorable court determined that the accused persons could not make an application for bail other than during the trial proceedings. That's the option of either bringing forward the trial and then making the bail application. It therefore then went to remove the matter from the law.
What is the judgment number?
The judgment number, my lord, is HH 409 of 24.
HCACC 183
of 24.
Well, those were two applications.
No, there were two accused persons. So one each has his own personal. Yeah. So, my lord, the submission that we make is that the finding of the court per se was that the law in its totality meant that upon indictment, an accused person cannot apply for bail until or unless the trial commences. And in effect, the law as interpreted by this honorable court is that an accused person's right to make an application for bail is, upon indictment, taken away and only restored when the trial commences. In our respectful view and in our submission, the law as interpreted in that is a contravention of the accused person's right to the protection of the law, the accused person's right to apply for bail. We make this submission, my lord, based on the aspect that in our respectful view, the Constitution affords an accused person the right to make an application for bail throughout the entire criminal proceedings. In other words, in our respectful view, the accused person as an example, is afforded a right even upon arrest to apply for bail to the police, to make a bail application to the police. An accused person is bequeathed with this right throughout the entire proceedings, even after conviction. A convicted has a right even to apply for bail pending appeal. So, at no point should the law take away or suspend that right to approach the court, to access the court for bail. So, the law is interpreted in the above stated judgment is that if an accused person is indicted today, that right is taken away. He can only ask the court to have the matter brought forward. If the matter is not brought forward, or if he does not ask the matter to be brought forward, it means the accused person cannot approach this honorable court, cannot access this honorable court to exercise his right to bail. And that is indeed a violation in our respectful view of the Constitution. Again, my Lord, it is our respectful view that this issue is not a frivolous issue, it's not a vexatious issue. It is a serious issue that the Constitutional Court must have something to say on, or with regards to it. So we seek
the Constitutional Court, was it not up to the accused persons to bring that matter before the Constitutional Court?
My Lord, it is a law that when something arises, the trial court that is handling a matter is a court that is better placed to determine issues.
Okay. No, the trial judge made that determination that I remember that you insist on the matter on the date determined in terms of section 160 subsection 1. And the accused person have the right to bring that date forward. The accused person said, no, they don't want you to bring that date forward. They are not in a hurry to be tried. They are just concerned about their release on bail. I thought that's what you said. Very well. You may disagree with that decision, but you could appeal.
My Lord, the decision of this Honorable Court, my Lord, was to remove the matter from the court.
It is appealable because it is the final effect that the application was not heard when you wanted to be heard.
It is appealable with the leave of the court, my Lord.
Well, that's a matter of interpretation. I have already told you my interpretation, which is that it is the final effect that the application was not heard when it was supposed to be heard. When you wanted it to be heard. So, whether you required leave, whether you did not require leave, well, those are different approaches. I will be of the view that you may not because of what I've already said. But even assuming you thought that leave was required, it's still a process of appeal. It comes back to, we still come back to the question, why wasn't the decision appealed against?
Well, my Lord, it comes to the same effect, my Lord, that it's the interpretation of the law, of the same provisions that were in Section 66, Section 137. And the law...
It's either you want to confront the person. It will help me in determining whether or not this issue should be raised now, whether or not it's frivolous, as you say. My question is very simple. That is a decision that was made by a court of first instance, which could, in my view, be appealed against at the time that it was made. I simply want to know why it was not appealed against when the decision came.
The reason why it was not appealed against is that it's not per se the decision of the court, but it is the legal provisions that the court related to. So those legal provisions.
It is not the decision. So in other words, you agree with the decision. You are just unhappy with the law.
With the legal provisions, yes.
So why wasn't referral requested in this case?
The same answer that I had given before that. In dealing with this matter, we are of the view that these issues will be brought in the trial proceeding. Because
this issue is concerned with a charge of fraud. That issue was concerned with bail. So the law was pertinent to bail, not fraud. Here we are congregated to deal with the charge of fraud. But in that particular case, we are dealing with an application. And the issue of that law came, and that was, in my view, convinced me otherwise. When referral ought to have been sought.
Well, my Lord, based on the exchange that counsels had with the court relating to bail, one of the issues that we felt was whether or not a trial judge could be seized with the bail application outside the trial itself. And
the issue, what the state submitted, is that the court will be properly seized with the matter on the date that it determined in terms of section 166. Or if the accused persons wanted to be heard in the matter concerning any relief, in this case that was a bail application, they were at liberty to bring the date of their trial forward so that the court becomes properly seized and then grant them, the so-called intellectual reliefs, whatever it is. But anyway, we are gravitating. What you're saying is that the law is brought about this injustice. And I'm saying, why wasn't referral sought in that particular bail application? Was those are the proceedings during which the law was applied, and its inconsistency with those constitutional provisions that have said would have arisen those proceedings.
The reason, my Lord, is that we agree with what the state indicated, that we could, the only circumstance or scenario where the accused persons could have a relief would have been in the trial proceedings.
You agree with the state?
That is we agreed with the state to say that we can then therefore only raise the issue once the trial starts.
So what is the complaint?
The complaints are the legal
If you agree with the state that the relief that you are going to seek would be sought when the court is properly seized with the matter in terms of the date which the state has determined.
Yes.
So what is the complaint?
The complaint is that those legal provisions being interpreted by the state to our agreement are or violate the Constitution.
Precisely.
Yes.
That's where we say we are in agreement with the state on these facts, but we are unhappy with the law. We want to challenge this law. We agree with the state that these are the implications of this law, but it's unfortunately prejudicing our clients. It's unfortunately in conflict with our clients' rights in terms of the Constitution. So before the law is applied, we want the law to be referred to the Constitutional Court. So that is when you should have raised it. You see, that's all I'm saying. And if you that's the impression I have. And if you didn't raise it, I want to know why you did not raise it. It's up to you to answer that question or to refuse.
My Lord, I'm urging this one, the court, my Lord, to have regard to the aspect that what we were agreeing with the state is that we could only raise those issues or seek remedy only after the trial is started. So we had to await. This is why.
What remedy?
The remedy for constitutional referral, the remedy for bail.
The remedy that you are seeking is bail. So the state was saying you may not seek bail now until the court becomes properly seized the matter on the date that they had determined. They told us that they have the prerogative to decide when your clients will appear in court.
Yes.
And they said they've done so in terms of section 160 subsection. And their argument was, if you want your clients to appear earlier than that, then move the date, because the law allows you to do so. Now you say that but you then said, we don't want to move that date. Now you agreed with the state that before that date arrives, your bail application may not be heard. But this was only because of the law. And you ought to have challenged the law before it applied. Now you cannot then challenge the law now when you allowed it to operate against your clients.
My Lord, the submission I was making was that the statement, the submission that not only do we deal with issues of bail, they indicate that bail or any other remedies can only be dealt with within the confinements of the trial every starting.
I think you answered the question to the best of your ability. You can proceed.
If you could just bear with me, my Lord. My Lord, I'm indebted to my brothers. The submission that we want to make, my Lord, is that the issue that we are seeking referral is arisen in these proceedings. And we are entitled, on behalf of the accused person, to raise them. The issues also concerns and relates to the accused person's right to a fair trial, which right has been held to mean being afforded the apparatus and the environment to prepare for your defense, including the right to be able to, if entitled to bail, to be released on bail prior to the trial, so that the accused persons prepare for the trial. And if those provisions violate the Constitution, it is an issue that ought to be referred, notwithstanding at what point they've been raised.
Thank you.
Thank you, my Lord. I will now move to the issue that we raised under paragraph L, whether sections 66, subsection 1 and 2, as read together with section 137 and 169 of the Criminal Procedure and Evidence Act in respect of an accused person indicted, such as the accused persons in counsel, and as interpreted by this honorable court under HH 359 of 24. In brackets HCH ACC 126 of 24 and HH 409 of 24 in brackets HC ACC 18324 of 24 amounts to a violation of their rights as accused person as enshrined in sections 50 and section 70 subsection 3 of the Constitution of Zimbabwe, and to the right to equal protection and the benefit of the law is enshrined in section 56, subsection 1 of the Constitution of Zimbabwe. My Lord, I've already related to the defects that are common cause. I have also related to the said provisions in motivating my arguments in respect of the other two aspects. I would abide by the submissions that I've made in those provisions. If you could just
proceed, Mr. Chairman.
Thank you very much. If you could just bear with me. My Lord, those are the issues that I had to deal with. I'm now handing over to Mr. Mclear to deal with them.
Lord, thank you.
My Lord, at this juncture, I'll pray, my Lord, that the matter be rolled over to tomorrow, postponed to tomorrow for me to deal with the remaining issues. My Lord, I am aware that we have since uploaded the record of proceedings in the court code, which effectively address or deal with the issues that we have raised in the application for referral. And I also noticed that we may be pressed for time, as it is almost 5 minutes to 4. My prayer, my Lord, would be that the matter be postponed to tomorrow to enable the record of proceedings to be before you. We have uploaded it, but it is yet to be approved.
But there are issues to do with section 160.
Can I do, my Lord?
The issue came. We have nothing to do with the record of proceedings in the magistrate.
If I may just confirm with my colleagues, I was of the view that perhaps this is the issue that my colleague was effectively dealing with. It's a matter of...
Well, it's up to him. Is that written?
It is indeed essentially relating to the provisions that I dealt with, my Lord. So we'll just abide by the submissions that we made.
So in issue I, you are not requesting me to refer any constitutional issue arising from section 160. You are not including section 160. Unless you are abandoning that. You think that
My Lord, we think would suffice with the points that we have dealt with when we abandon this particular point in relation to section 160.
My Lord, while this I'm still on my feet, we're also abandoning J, which is whether these charges, in so far as they relate to the failure to supply goods as per contract with the ministry amounts the violation of his right, not to be imprisonment on the grounds of inability to fulfill contractual obligations.
what number is it?
It's J, my Lord.
Paragraph J.
Paragraph J, yes.
Row, I have noted this. Let's look at what we have covered so far. We have covered the issue in paragraph A.
Yes, my Lord.
Issue, and that's B and B as well.
Yes, my Lord. A,
C.
B, C, D, also abandoned E.
Yes.
I believe F is really more or less a repetition of the submissions that were being made.
It relates to G to E, isn't it?
Yes.
So it naturally falls away.
Yes.
So F is abandoned. Now G is what you are going to motivate tomorrow.
Yes, my lord. G and N.
N.
Yes, my lord. N.
Yes, and what are the issues?
My lord, I believe those are the issues. The other ones have either been abandoned or they've been dealt with. My lord, sorry, my lord, I also noticed there's K. K, there's
About selective prosecution.
yes, ma'am.
That selective prosecution, cherry-picked charges. What is that? What do you want to go to do? Or what about selective prosecution? Prosecution is a constitutional prerogative of the prosecutor general. The court cannot interfere with that prerogative.
If the government just the SBA with me consult with my colleagues. My lord would want to deal with that issue. And really it's a question of whether or not the accused persons are being afforded the full benefit of the law, and will motivate that ground tomorrow. Whether or not then the court makes a finding if it is frivolous or vexatious. It's something that is within the prerogative of the court to make that determination. But our clients believe that the law is being applied selectively in as far as these proceedings, or the criminal proceedings, are concerned, and that they are not being afforded equal treatment and equal protection within them.
Yes. No. Just put it in other words. I'm not following. You are saying that there's selective prosecution.
Yes,
And I'm saying the court does not prosecute. I don't know what you want to motivate, because if it is about selective prosecution, and that's the belief, whatever that means, but clearly the court does not get itself involved in determining who should be prosecuted, who should not. And we are a court of law. I cannot really be in breach of the Constitution, by trying to interfere by being invited to interfere with the prerogative. I'm simply resisting that. Well, if you, I'm already giving an indication that I'm disinclined to be giving instructions to the Prosecutor General because the Constitution is very clear about the prerogative of the Constitution. Whether or not the Prosecutor General is here, or whether or not I don't want to do it. I don't want to give directions because the law is very clear. If you read it, it says the Prosecutor General shall not be subject to any direction, and the court is not above the law.
My Lord, I think the point that the accused persons are making is not necessarily that it is this court which is violating their constitutional right. But what the accused persons are inviting the court to do is to make a determination whether or not there has been a selective application of the law. And therefore, that then violates...
I mean, it's based on what facts? On what facts? You are going to give me a list of the cases that were supposed to be prosecuted, which were not prosecuted.
My Lord,
I see Mr. Story could disturb you.
Perhaps, my Lord, let me defend.
But he's not representing, he's the one representing. You can defend him.
Yeah, we are appearing for, it's a joint application, my Lord. We will appeal.
Yeah, but it should be systematic because at the end of the day we'll speak at cross purposes. If Mr. Story is going to be the lead counsel on that point, then he should be. Yes.
Yes, let me defend.
Below that, only I'm related to the judges. I realized if I continue to whisper to you, it might not be, as is also shooting the question, be unable then to express the context of what we tend to argue. He is certainly the lead counsel on that point, but the issue, my Lord, is not really impugning the court, but it is a point which arises from Smith versus Chimombe, where you can look into the conduct of the prosecutor, because that conduct of the prosecutor or the prosecution, if it has a bearing on the right to a fair trial of an accused person, it becomes an issue which the court is seized with to answer whether the rights of the accused person are being protected when we look at whatever they are alleging in respect of selective prosecution. So it's not an attack on the court, but it's an impugning of the conduct of the prosecutor to then measure up to the
I remember I read that matter. Was it not a review?
Pardon?
Was it not a review? How was it brought before the court?
Well, my Lord, if my lady friends can look it up, because on the issues whether there was a review or not, I'm not too sure. But in terms of the principle that the court can look into the conduct of the prosecution in respect of its impartiality.
Is that case involving what is the name of the case? The name of the case?
I don't know whether my pronunciation is correct. Smith versus Mpofu. S-M-Y-T.
Mpofu was the prosecutor.
Well, I was too young to know that was the
I simply remember that case. It was concerned with the conduct of Prosecutor Mpofu during that trial.
Yes.
Yes. During the trial. Yes. But not in arriving at a decision to prosecute. All I'm saying to you is, we should respect. We are here because the Constitution is considered sacrosanct, and the court is the upper guardian of the Constitution. I will not be tempted to violate it because I'm the court. All I'm saying is that we all know that it is unambiguous. The Constitution is unambiguous in terms of the prerogative of the Prosecutor General, and that is not subject to any direction. So I'm very slow. I'm very disinclined. I'm only indicating that I'm very disinclined to be drawn into a discussion as to who the Prosecutor General must prosecute and the basis for that decision. In other words, it's his or her prerogative, and is not accountable to the court. But there are, of course, certain circumstances where the decision may be reviewed. But they are very Very, very narrow. Very, very narrow. Because that is a constitutional provision, and I don't want to find myself in contradiction with the Constitution.
May not be, definitely there's also a judgment which is Lordship did state as Sifan, and you still express the same.
Yes, because of what was happening in that trial. I know that. I know that judgment. And I was actually emphasizing that it is the prosecutor who must exercise this prerogative without any interference. That was the point, wasn't it?
Indeed.
Yes. So I don't want to go against the principle. I don't want to go against the Constitution. I don't want to go against the judgment which I have written. You really are inviting me, because what we will do in this case, the factual basis here is not yet there. I thought it was not good, because I remember earlier on indicating that in terms of our sub-judice rule, you know, the public is not allowed to influence the court by expressing sentiments, you know, their views of the outcomes of the matter. And I said, maybe you're not here then, I think you may agree. Let's not violate that rule by placing before the court issues unfolding in the social media. Because I don't want to be influenced. You, as part of the court, you should not be influenced. My advice was actually, if you come across the story, flip over it, leave it. Because then it will influence you. But yet, as a court official, you are trying facts before. And so I'm still, it is just, I'm sorry that I haven't gone this far to explain the court. It's all to do with sub-judice. We don't need to bring into court facts that are not supposed to be before the court. I really want you to reconsider that and consider whether you can still do that. When we reconvene tomorrow, you can, perhaps if you still believe that you must place it. But I certainly don't want, I don't believe it right to allow social media issues to be put in this court. Because I don't want to know them. I don't want to know how people are judging this matter. Because evidence has not been laid.
Lord, I've read it.
Yes. I urge you, in the interest of the law that we all stand for.
Yes, sir.
Yes, not to irrespective of the interest that you may have in defending your clients. But let us remain within the correct lane, which is the law, which we all stand for.
We intend to, in motivating that point, to be within the full confines of the law. Lord, I've had my learned friend indicating about a postponement to tomorrow. I believe lead counsel and I have a difficulty with it. Maybe that issue would be, it might be an opportunity to address it. For myself, if the matter is proceeding, I would ask to be excused. I need to travel to Butare appeals high court, the criminal court, to deal with the matter which was said.
Perhaps after discussing the case, you want to excuse yourself? I'm not sure what you're asking me. You have not really put your position clear.
Maybe I'll leave it to learned friends to address that issue
tomorrow.
It has to be.
Or you mean you are confessed?
Yes, I was going to suggest that if it is going on, myself I can be excused, but it's fine.
My Lord, I believe that the issues that we want to motivate and deal with tomorrow, we can deal with them without the presence of...
you mean you can dispense with his presence?
I'm not so sure.
It's more polite to say it that way.
I'm sorry, my little friend isn't allowed to say what he was saying. We need to get to that point when we reach it. He was finishing his submissions, and then if the court then wants to then deal with what we do at this point, then we have to address.
I think he had finished, he had asked for postponement.
Yes, my Lord, I done.
We're in the process of identifying the issues that remain. And I was just concerned about what issue was it?
K.
Okay, I'll tell you. My only concern was maybe to make it clear that there's mention of wanting to prove linking texts, audios, pictures, and videos in which people were discussing certain things. And I'm already indicating that any attempt to prove things unfolding in the media, in the social media, certainly be welcome.
We hear you, but we understand.
Yes, but anyway, like I said, at the end of the day, you are entitled to move the court. The court always approaches matters with an open mind. If you think you can convince the court that such evidence may be placed before this court, you may. In which case, then we are back to that situation where we need now to consider how such evidence may be placed before this court. Because that ground will not arise until the videos, the audios, the texts have been proved.
Yes.
So we will need then to suggest the court as to how to deal with that particular aspect.
I agree, my lord. We'll stay guided.
In the meantime, you can discuss that with the state. Sometimes it helps when you reach a consensus, and then place your consensus before court, and the court then consider whether it's acceptable. So we convene tomorrow. We reconvene tomorrow. Yes. Tomorrow will be there.
We need my lord, to deal with tomorrow. I mean, it's not court and my other friend is not there as well tomorrow. We might need to discuss the appropriate. We're not direct for tomorrow when we.
Oh, yes.
Last time it was on the 22nd, so our diary is for tomorrow and the next day. Right?
So we need to discuss.
We need to discuss an appropriate date.
Is it something that you can do right away? Fixed. Because the accused persons are in custody, I think we have to do that. So you tell them when they're coming. State, what do you think?
The state will be in attendance. I think Mr. Mkia said the rest of the issues is neighbors when we handle them. So I think we will deal with the matter with Mr. Mkia. He had excused his two senior counsels.
I think, my lord, that is the issue I said. He's not allowed to say that. From what we have seen and the way the trial is progressing, even when one of us is assigned a particular portion, we need the whole bar to do that. We have learned from today that from time to time, even those that are not assigned a particular issue, have an input. So we have to find a time when we are all it appears issues are getting more and more serious and more complicated. So we need times when we are all there. That's, I think, that is in the best interest of the accused persons.
Yes, it still brings us to the situation that in a criminal case, we may not just leave it open. We need to postpone the trial to a specified, specific date. So we may confer amongst ourselves and liaise with the state council.
The court would be with us.
My Lord, subject to the court's blessing, we propose that we postpone the matter to the 29th.
Registrar? We are not sure about the availability of the this is because there is a supposedly the itinerary place to see the supposedly was start on 30. Usually when it is like that, probably means that the 30 is the travel date. Maybe available on the 29th. So, if that is the only date on which council will be available, we will postpone the matter to the date. But you need to be aware, in the event that that is the travel day, we will only continue to find another solution. But it may well be that I will be available. Like I said, from experience, usually the date, even as the date on which the conference starts, usually travel. So she has not been able to, because we have not really received any communication on the travel arrangement. So we are unable to say whether or not. So we will postpone the matter to the day. Should there be any, should we become aware that there will not be available on that day, my researcher here will communicate with you in advance. Fellow stand-up accused persons, your trial is postponed to the 29th of October for continuation, at 29th October for continuation at 10 hours. 10. I'm sure you've heard the explanation that I've given to your lawyers, that that date is tentative. It might well be the date of continuation. But in the event that it turns out that it will not be available, that will be communicated to your lawyers well in advance. As soon as we become aware, then the appropriate date will be communicated at the same time. But all the same, whether or not the trial will continue, you are still required to obey. Is there any other business registered?
No.
The court will rise.
I will affect someone who was thinking.
No, issue here,